Hi, everyone. Harry here to talk about the just issued decision from Judge Charles Breyer in the Northern District of California, holding that the United States violated the Posse Comitatus Act and in a flagrant, intentional way in its deploy of federalized National Guard troops and military personnel as well in Southern California. Recall, Trump sends in these troops over the objection of the governor and the local authorities there who say, we're doing fine. We don't need you, Mr. President. The few times in which this has happened in the past has been times where the states have said, please, we're beleaguered. We could use you for a couple days to just sort of right the ship and then leave. Trump had nothing like that in mind. Rather, he had a permanent kind of takeover, as we've seen in D.C. and even seen in California, where troops still remain. So he storms in over the objection of people in California and does these very heavy-handed raids with National Guard as well as military personnel who ostensibly, the military personnel were there only to give ancillary support to the guards as is required under the law. And the law here, and the law that has been violated, is called the Posse Comitatus Act. And it's a statute on the one hand, but it's really an expression of a very basic principle of a democratic society, which is the military does not do domestic law enforcement. You see boots in the streets and military making arrests, seizing people and property. That's a totalitarian society. And it's just completely a crucial principle that doesn't happen. And that's what the Posse Comitatus Act is there to ensure. Now, there is the, and I want to, as you probably hear, I have a little bit of a cold that I acquired, but so sorry about that, but soldiering on. There are a couple small exceptions to this principle because crazy shit happens and you may need a really temporary kind of use of the military just if a state's law enforcement system is totally overrun. So in the riots following the assassination of Martin Luther King in the 60s, there was a time where Johnson federalizes the National Guard, brings them in briefly. In the early 90s, following the Rodney King trial, a couple days in which there are riots that just overrun the local authorities in California. And there are very narrow statutory exceptions. And the gist of Breyer's order here is this ain't that. And it really isn't that. So he previously, now you may remember, Breyer had already held that the authority that Trump purported to exercise to actually federalize the National Guard was unlawful already because that section, that narrow provision there required that there be an actual insurrection or rebellion afoot. There isn't, and that made it, therefore, unjustified in the first place. That was the order that the Ninth Circuit put on hold and is still now on hold, but the overall issue will be decided and will return to Breyer. This is the broader, more important issue of the Posse Comitatus Act itself and whether the U.S. violated it on the ground. So the basic principle is don't do law enforcement. And you may remember Breyer had a 3-day hearing in which he took testimony from different people, including one of the people who were supposed to be in charge of this whole operation, who said, I didn't really see any kind of emergency there. This was someone working for the U.S., and others who said, I actually objected to our doing this. But Breyer, having taken evidence and testimony, now comes out with this scholarly opinion that first goes through the whole importance of the Posse Comitatus Act to a democratic society and the why it's something that only in the most temporary and exigent circumstances would you ever think about making the military a kind of ancillary domestic law enforcement. And then he just goes through the facts, and they did on the ground all kinds of stuff. He finds it's exactly what the Posse Comitatus Act says you're not allowed to do. Now, to hear Trump talk about it, it certainly seemed like that was what they were doing. They were going in and knocking heads because there was an emergency, and they were going to clean up Dodge and shore up the terrible situation in California. That's, of course, not what they said in court. In court, they said, oh, no, it was really just sort of temporary, and we were just kind of, the military was only doing auxiliary help, and they weren't making, and the National Guard weren't making arrests, but the facts are otherwise. And indeed, we've seen this in D.C. too. They send in the people, and it's a really kind of martial, knocking heads sort of force to actually be the substitute for the cops on the beat, which, of course, they have no idea what they're doing. This is true in D.C. It's true in California. It'll be true in Chicago if that's where they go next. So Breyer finds that there's really flagrant violations of the Posse Comitatus Act. And so after the whole historical analysis, Breyer just, goes through, says, look, the record is replete with evidence that Task Force 51, those are the federalized National Guard, executed domestic law in all these prohibited ways. It set up protective perimeters, traffic blockade, crowd control, and the like. There's just no exception to the Posse Comitatus Act for such conduct. And neither Trump's memorandum nor a follow-up one from Secretary of Defense Hegseth changed that. So basically, he's saying they sent them in and they talk a nice game in court, but in fact, I'm finding all these ways in which they violated the Posse Comitatus Act, and not just that happened on the ground, but these violations, this is maybe the money quote of the whole opinion, were part of a top-down systemic effort by defendants to use military troops to execute various sectors of federal law, the drug laws, the immigration laws at least, across hundreds of miles and over the course of several months and counting. And the instructions to train Task Force 51 on the constitutional exceptions and what they're allowed to do and not do, but in fact were trained to violate, came all the way from the top at the Department of Defense. And that's, again, testimony at trial saying this is really from the top and what Hegseth wanted. So it's a very categorical indictment of what the administration was doing. And it seems very, accurate with all the facts as we've had them. They've always tried to present a laundered version of facts in the court, but it seemed they did exactly what Breyer's found they did, came in to crack skulls and support drug laws and immigration laws, not any situation of just where domestic law enforcement was overrun. So there's also discussion. All he can do, so he finds these are violations and he enjoins the defendants. Here's the actual order: from deploying, ordering, instructing, training, or using the National Guard currently deployed in California to execute the laws, including but not limited to arrests, apprehensions, searches, seizures. So it's a very strong injunction, but it applies only in California. That's what's in front of him. Nevertheless, he discusses the other situations, and unless this opinion is suspended, and Breyer does suspend it for 4 days to permit the administration to seek emergency relief in the Ninth Circuit. But if it doesn't, if it isn't reversed and it holds, it's going to cast a very large shadow over the efforts by the administration to try to pull this same trick in Chicago and other cities around the country. Because once again, it's really, they might talk a certain game about why there's an emergency under the law, but it's quite clear what they're doing is just federalizing some troops to go in and do anti-immigration, anti-drug law enforcement. There is no emergency, and it's a kind of maximum leader bully boy charade and one that also is not limited in time, right? Until today, that there were still some troops in California, and Breyer says, but they're not doing anything anymore. They better, they can start playing cards or whatever, because no arrest, no nothing. We're going to see this opinion be the sort of starting blocks for subsequent states like Illinois, where both the governor and mayor have said, stay the hell out of Chicago, please. We don't need you. This is going to be the sort of framing opinion, unless and until it's reversed. That's going to be the pretty definitive rebuke of the efforts that Trump has been trying now for over a month to just basically declare an emergency and take over local law enforcement. It's a meticulous, well-reasoned, and important opinion that is going to be the kind of standing instruction until the Ninth Circuit or Supreme Court says otherwise. Talk to you later.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.